Good morning, Chief Justice. I am comfortable. Good morning, members.
Apologies again for the earlier confusion. Oh, how are you, by the way? I've not seen you in many, many years.
I'm fine, thank you, Chief Justice. I hope you are also well.
I am, thank you. You have appeared, you have sat in that chair, well, maybe in a different room, but before this body. Is this the third time now?
No,
the second time?
No, it's the fourth time.
The fourth time?
Yeah.
And the latest appearance was in late May, just 4 months ago.
4 months ago.
So
yeah.
you know the drill. You're familiar with the process.
Yes, I am. Thank you, Chief.
All right. You started your legal career as a prosecutor in 1986.
That is correct.
Mm-hmm. And left in 1991 to join the magistracy.
Yeah, that is correct.
Mm-hmm. And you were a magistrate for a number of years until late in 1998. And your CV indicates that you were one of the lucky ones. You did both criminal and civil work in the district court.
Yes, I did.
Okay. Then between 2001 and 2003, period of 1.5 years, you were a director at the Family Law Center.
At the People's Family Law Center.
What? Just explain what that is to me.
The People's Family Law Center was established as a center for family-related issues. We would screen your application. We would prepare your application for court, but not appear in court for you.
All right. So you were there for almost 2 years. Then returned to prosecution.
Yes,
in
to the asset forfeiture.
Yes, right. And then you started acting as a judge in 2008.
Yeah.
And in the Western Cape Division of the High Court.
That is correct.
Okay. And that's where you are still stationed, except that you are acting at the SCA at the moment.
I acted at the SCA until the 30th of September of this year, from the 1st of December.
All right. But you had acted in that court previously in 2015?
Yes, I did.
For 4 terms?
4 terms, yeah.
Uh-huh. And you have added 3 more terms now?
Yes, yeah.
Well,
that is correct.
Okay. You come from the second busiest division in the country, so one would imagine that you've dealt with the widest spread of cases on all aspects of the law.
That is correct, really.
And the SCA stints would have only served to broaden your experience.
Oh, yes, it did. Thank you, it did.
Okay. You indicated in your questionnaire, the JSC questionnaire, that you had, or am I confusing you with another candidate? Do you have any reserve judgments?
I had one, and it has since been delivered.
All right.
That was one at the SCA, and it was delivered.
Oh, that's the one that was delivered in July?
In July,
all
yeah.
Right. Thanks for that. I forgot to ask you about your legal qualifications, but then you wouldn't be a judge if you didn't have a law degree or 2 under your belt.
I've got a B.Juris LLB.
From the University of the Western Cape.
Western Cape.
All right, thank you. Is there any reason why you have not disclosed your date of birth? I see that in your application form you referred to an annexure, and I looked for this annexure A and could not find it.
It is attached to it.
But why did you not just state it
because they asked us to give that detail in Annexure A.
Oh,
that was why.
All right. But I don't have an Annexure A.
Annexure A asks for my date of birth, ID.
But then you can just tell us when you were born. South Africa has the right
okay,
to
no,
know how old
just-
this judge wants to ascend to the SAA.
Date of birth 3/12/1960.
1960. Okay, thank you. Okay. I think I'll leave my questions for you at this stage for now, and I will hand over to Deputy President Zondi, who represents the SCA today.
Thank you.
All right. Sorry, still morning. Hey, morning, Judge Baartman.
Good morning, Judge Zondi.
You have been with us at the SCA for some time now. How have you found the experience there?
The experience was very good for me. I adapted well to it, and I managed the work, and quite enjoyed my 3 terms there. Yeah.
And then in terms of the work exposure, you have been exposed to all kind of work that we deal with at the SCA. Is that so?
Yeah, that is correct.
You are aware that the SCA at the stage at least will need somebody who has some knowledge on tax, commercial law, and IP, intellectual property. You do not have a problem with those aspects of the law.
I have done tax law
Yes.
before at the High Court. Yes.
I just want to state that I haven't had any sort of negative comments from my colleagues at the SCA, and all our colleagues have said something positive about you. Thank you, CJ.
Thank you. I also enjoyed working with him. Thank you.
Good morning, Judge Baartman.
Good morning, Judge Mlambo.
I want to tell the Commission that you were one of my best students when we were training SCA judges on case lines. Could you just give an indication of, if you know, how many full court appeal panels have you presided in the Western Cape? If you can.
It's too many. It's over 15 years.
Too many.
Yeah.
Thank you. In the SCA, have you written any judgment that involved a constitutional issue?
In this last session, no.
In another session?
I don't have it right in front of me now. I'm not sure.
I'm struggling to hear you, sorry.
I'm thinking now, but I can't tell you offhand what I've written. It was some time ago that I was there.
I see, but you have presided over a matter that has a constitutional issue.
Oh, yes, for sure.
I see. Okay. Thank you very much, CJ.
CJ, I thought you'll start with the minister thereafter.
There's no problem, actually. Now that you have given me, thank you very much, Chief Justice, and good morning, Judge Baartman.
Good morning.
Thank you very much. As a judge of the Supreme Court of Appeal, how are you going to deal with cases where you believe judicial precedent as set out by previous courts is outdated and possibly does no longer address the interest of justice?
We deal with that in the High Court as well. If that happens, you look at the case in front of you, the facts in front of you, the pleaded case, and determined whether this is an appropriate case to develop the law if the facts meet that sort. And yeah, you would do that. It's the case in front of you, whether that case is right. Even if the case is not right to develop the common law, it is sometimes appropriate to make remarks which other courts used afterwards to develop that.
In instances where there are divergent views, as the judge who possibly could be appointed on cases that you are dealing with in a panel, how are you going to deal with disagreements? And how are you going to ensure you maintain the independence as a judge, but also leading a panel, of course?
You do that often when you in the High Court and you're the senior judge in an appeal with two. Sometimes people have very strong views opposing you, or you might have strong views. There's nothing wrong with that. That's what we meant to do. We meant to make our points forcefully if necessary, but always respectfully. And you must always be able to then write a dissenting judgment. Yeah.
Chief Justice.
Thank you, Minister. Commissioner Kane?
Thank you, Chief Justice. Good morning, Ms. Baartman.
Good morning.
Have you had an opportunity to carefully consider the review that was presented by the GCB?
Yes, I have.
Now, in that review, they raise a couple of things. The one is that you hadn't supplied your date of birth,
Yeah.
and the Chief Justice took that up with you, and you said it was required to be done in an Annexure A.
Yeah.
I also spent some time looking for Annexure A, and whatever is attached to your application doesn't seem to deal with that question. Are we missing something?
I don't know, but there was a loose annexure, and that asked for my personal details. In fact, I have a copy, and I'll hand it up.
Thank you. Perhaps I can have a look at that just now.
CJ, I wanted to propose that the candidate bring the mic closer to us. So that
Just bring the mic closer to you, Judge Baartman.
I should move closer to
You
the
can't
mic.
pull it forward.
Yeah.
We don't want you
Okay. Is that
hitting your
better?
back.
Okay.
Okay.
I have annexure A here.
Thank you very much. I'll certainly
It
have a
has
look at that.
My name, my cell phone number, residential address, and ID.
May I take you then to matters of some concern in the GCB's report? They have traversed a number of your judgments, and what they raise are issues pertaining to judgments you gave. They say that you dealt, for instance, with an issue of prescription without having any of the primary facts before you. They say that you misunderstood the nature of discovery and what the purpose of that was. They say you really misconstrued what would have been a condition and took into account completely irrelevant considerations and veered off course, and that your conclusion was legally untenable. Those are criticisms you would have seen, and I would like you please just to deal with that and persuade the Commission that in these areas of civil law, that you do indeed have sufficient experience to deal with those kind of aspects.
Okay, thank you. Can I deal with the matter of Grootkraal first? In Grootkraal, it was a matter of mine that was upset. If you go to paragraph, you might not have the judgment in front of you. I have the appeal judgment in front of me. And paragraph 20, is that Sorry, just a minute. Paragraph 20, the court sums it up. The court says, Groot Karal's history is bound up with the history of the missionary activities in this part of South Africa. And then he says, the parties dealt with this on a relatively cursory basis. In the result, some of the assertions made were more the product of legal drafting than historic facts. And then the court proceeds on paragraph 21. It says, much of what follows is drawn from these sources and has been used to complete the correct picture drawn by the parties in their affidavit. Now, this is one of the matters that I was upset. But if just look at paragraph 20. Evidence was placed before the court on appeal that I did not have. I could not possibly have reached the same conclusion with different evidence. That's the one that I just want to deal with. And then the other one is the matter of Claire Howman and the Kingsbury Fetal Assessment Centre. Was also a matter that went to the Constitutional Court, and what happened in that matter, the matter came before me as an exception to pleadings. The normal order would be, if you uphold the exception, is to send the parties back to deal with it. I was specifically asked to not give the normal order because the year before, the Kingsbury Fetal Assessment Centre and another party went all the way to the SCA. At that point there, they were sent back. Now they had another patient and they wanted to test the same proposition in the Constitutional Court. So the Constitutional Court said, I should have criticized me for not giving the usual order, meaning give them an opportunity to amend their pleadings. But I was specifically asked not to do that. And you're dealing with a fetal assessment center, you're dealing with unborn children. It was necessary to test that proposition in the Constitutional Court, therefore that order, just to deal with that one. You have then raised the other issues that I've looked at those cases. One of the matters that's before me, you must understand, if the matter is presented as a prescription issue to me, that is what you deal with and that is what you answer. I take the criticism that on appeal the matter is upset. That happens, but it doesn't mean that you didn't know what you were doing. We get it wrong from time to time. In the church matter, the Lutheran Church, there you had a poor community. They've had that church. They fell in arrears. The place was falling apart. They came to court. They had a plan, They couldn't go to a bank and borrow money to get the church and the school going. They asked for an opportunity. There were negotiations between them and the municipality. So if the court says she took other considerations into consideration, that is correct. That is what happened on the day the law is not just tick boxes. You're dealing with people, and sometimes you go too far. This Groot Karal matter is such a matter where the appeal court went and found the records that the parties did not put before the High Court. I hope that answers your question.
Thank you. You've certainly given good answers. Do you want to also deal with Caxton and the discovery aspect?
Caxton matter, you must remember those parties are actually opposition parties, and the one party purchased some of the other parties' they purchased some of their stocks, so they were now a party to it. And it's on that basis that they were fighting all the time. And the senior company was going into litigation with basically one of his shareholders because they bought some of the shares. And it's from that perspective that I said, but there is preceding spending. The main company is going to institute litigation against you, and the appeal court said no, but they are parties and they are entitled to it. So, yeah.
Chief Justice, may I just also place on record that the candidate has produced a document which has the heading Annexure A, and it appears that it may have been omitted from our papers. It doesn't bear the birth date, but it does have the identity number.
Thank you, Commissioner King.
Thank you.
Okay. While I have my finger on the report which Commissioner King has just questioned you on, let me ask you just to bring something to your attention and find out if you would like to comment on it. I agree with Commissioner King that the responses you've given in explanation for these judgments of yours that were overturned is all explanations are good. But the concern that is expressed is that of the 18 judgments of yours that have been taken on appeal, a majority was overturned.
This is why
Out
I
of
say,
18, a whole 10 was overturned.
but the the Kingsbury matter, if I didn't think of some other considerations than my career, I would just have sent them back to the drawing board. But you take the risk because we needed the Constitutional Court to say something on the issue. And in the other matter, I didn't have the facts. So I could not have granted that order minus the facts. In fact, the parties didn't have it. The court found it.
No. I was hoping you would also say that you've written many judgments over the years which were not taken on appeal and still stand. So we can't judge you by the 10 that you happened, well, someone thought you got wrong.
Yeah, and it's 15 years,
Yeah.
I must say. We write many judgments every day.
All right. Thank you, Judge Baartman. Commissioner Tsweni?
No, thank you very much, Chief Justice, and good morning to Judge Baartman.
Good morning,
I
Commissioner.
think we've dealt quite extensively because one of my concerns was also around your judgments that were overturned, and I'm being persuaded by the discussions that ensued here. But over and above that, we've heard earlier on that you've been with the Supreme Court of Appeal. That has obviously earned you quite a bit of experience in that regard. I just want to know, added to that, what is it that has motivated you to apply for this position?
I have been on the bench for a long time, since 2008 when I started acting. You assess your judgments, what comes back from it, and your own readiness. And in 2015, having done a year there, I was then persuaded, and am still now, that I am ready to make the contribution that the court needs at this stage.
No, thank you very much, Judge Baartman. Thanks, CJ.
Thank you, Commissioner Mtsweni-Sipane. Commissioner Kotsa?
Thank you, CJ, and good morning, Judge Baartman.
Good morning.
You spoke about developing the common law earlier,
Yes,
and in what is known as the Dalai Lama matter,
yes.
which is a pretty old matter by now, the SCA overturned your judgment and considered that the question of whether or not the authorities had acted lawfully was and remained a live issue. The General Counsel of the Bar thereafter then commented on your judgment and said that the judgment appears to be indicative of the candidate's tendency to apply the law somewhat mechanistically, and they also said that you've not used the opportunity on the facts applicable in certain cases before you to develop the common law. This was around about 2018. So my question to you, has there been a concerted effort since then to focus on these comments and in particular to develop the common law?
Okay, thank you. Can I reply like this? I was one of two judges on that bench. The facts in front of us was what we dealt with. As I indicated earlier, if you want to develop the common law, it must be done case specific. You must have the facts to do that. You cannot just develop the common law in a vacuum. And you cannot apply the law mechanically, really. That is why I got into trouble with the Lutheran Church, because had I just applied it mechanically, and also with the Kingsbury matter, then it wouldn't be held against me. So, thank you.
Commissioner Hassan?
Thank you very much, CJ. I'm over here. I know it's
Hi.
a
Good
little
morning,
difficult to find
Commissioner.
all of us. My name is Fasia Hassan, new commissioner for the JSC from the National Assembly. Judge Baartman, I'm going to cover somewhat of a less technical matter, and it's related to the Boyson case, though unreported. And I found it very interesting, Judge, your approach to centering victims' voices and the manner in which there was an attempt to, I think, craft for the survivor by the perpetrator their response. And so my question really is, do you think that this particular area of law has developed sufficiently to help combat GBVF? But I'm also interested in your experience and your work in the sector, both in the earlier part of your career, which we've read about, but also now, and what you think needs to happen in terms of furthering the process for centering victims and survivors of GBVF. Thank you.
Thank you. There is a lot of work that still needs to be done. From the court perspective, what we can start doing and are most certainly encouraging is for people to speak up. Therefore, that judgment says the abuser cannot tell the victim how to complain. Our courts are still crowded. You come to court and it's secondary victimization, sitting there the whole day. They opposite you. A lot, honestly, a lot has been done on the ground in the lower courts. People are paying attention to those issues. We have space issues at courts. That is a problem. You're dealing with a relatively high turnover of clerks, not specialists in the field. That is another problem. What my personal experience, what I often see is that there's no counseling which should actually be attached to the court, that center. I don't know, the money isn't there, the accommodation isn't there, but that is most certainly needed and can be done. Okay, thank you.
Thank you. Any further? Commissioner Maiman?
Thank you, Chief Justice. Greetings to you, Judge Baartman.
Good morning, Commissioner.
Just from my side, yeah, The first one relates to the fact that indeed it is not for the first time that you are here.
No, it's not.
So therefore, I think the first question will be, what is it that you want to give to this panel that will make a distinction between the previous decision and the new decision that will elevate you to the Supreme Court of Appeal, given the fact that the last time you were not successful. The second one relates to, given the departure of senior justices from that Supreme Court of Appeal, either through elevation to other more senior position, like the CJ, and also the other through retiring, like the Deputy President, Pete. The question that I want to pose to you is, what are the unique contributions and value adds that you will be bringing if you are appointed to the Supreme Court of Appeal, given what I've alluded earlier on? Thank you.
Okay, thank you. Thank you, Commissioner. The Supreme Court of Appeal have lost a lot of experience. What they need is a judge that you can say there's a 60-volume matter, get on with it, and get on with it. That's what they did to me in December. I got on with it. They need people who can hit the ground running. After 15 years on the High Court bench, a very busy court, and we all know our court is busy, I can do that. That is what I bring, a willingness and able to work, and that's what that court needs.
Thank you, Judge Baartman. Thank you, CJ.
Commissioner Balui?
Thank you, CJ. Good morning, Judge.
Good morning,
Yes,
Commissioner.
Judge, to go back to the GCB comments. Now, they comment that the Chief Justice has spoken to you about the number of appeals, matters that were taken on appeal, and what the GCB says about it. Now, I think you should at least have the opportunity to comment on this.
If you can just stay behind the microphone, I can't
Okay.
hear you.
I
Sorry.
do apologize.
Thank you.
So what the GCB, you would have seen in their comments, say is relate, and which I'm raising with you, the Scalabrini, you have listed it.
Yes.
Scalabrini and then PEPCO, and Lambertus van Velach as matters that, as application, leave to appeal or appeals that were upheld, right?
Yeah.
Your judgments were
Yeah.
upheld, you say. Now, the GCB says about Scalabrini that you say in paragraph 16.1 that you refused leave to appeal in the matter, and therefore it's not clear when you say your judgment was upheld on appeal if you did refuse leave to appeal. That's about Scalabrini. If you can just keep that in mind, let me give you the others.
Yeah.
And then with the PEPCO matter, they say you granted leave to appeal and the SCA struck the matter from the roll. And then you list it as a matter, as a judgment that was upheld on appeal. And then the Lambertus van Velach matter, they have not been able to find a judgment on appeal. Now, if left without comment from you, it may create the impression that you might have listed, you must have stated this as upheld judgment when in fact they were not. Perhaps you want to say something about them?
No. The Scalabrini matter, There was an application for leave to appeal in front of me, and I refused it. So then they must go to the appeal court, they must do something else. They haven't done it. So they asked for leave to appeal, and it was refused. So it's properly there, an application where leave to appeal was refused and the matter was not overturned. The other matters, if I refuse leave and they go to the SCA, they petition the SCA for leave to appeal, and then they don't grant it. The SCA is not going to write a judgment on that. Every Tuesday you get your petitions. Those are judgments where the High Court refused leave. They then petition the SCA for leave, and then it's refused. That is properly a leave to appeal refuse. With respect.
All right. Yeah, all right. I'm not sure I understand how those two amount to your judgments being upheld. I mean, if you refuse leave to appeal, maybe let's go back to Scalabrini. You refused leave to appeal, as I understand.
Yeah.
I'm not understanding from your answer whether are you saying they then petitioned the
And then-
SCA and they were refused leave?
Then the SCA refused, which means they upheld my judgment.
I see. And then with PEPCO,
It's the
the
same
matter was
thing.
struck from the roll. Why
but
do you
they-
say that is well, the GCP says that matter was
I
struck
don't know.
from the roll?
Well, they petition, matters get struck from the roll because they're late for various reasons, but they don't hear the appeal.
Yes, but you
Then the
consider,
appeal's upheld. You must remember very often parties bring condemnation applications, and depending on the merits of the matter, they do or don't get leave to appeal or condemnation.
okay. Thank you, Chief Justice.
Thank you, Commissioner Barroy.
CJ, may
Commissioner
I just
King?
follow up? I need to understand your answer, please, Ms. Baartman. On the Scalabrini matter that's just been debated with you, as I understand it, there was a judgment ultimately that gave relief by the Constitutional Court.
Yes, that was in Part B.
Oh, I see.
Yeah.
Okay, thank you. That does explain it.
Yeah, okay.
Are you satisfied, Commissioner King? All right. Was your hand up, Commissioner Notjes? Oh. Commissioner Trollip.
Thank you, Chairperson. Judge Baartman,
Good morning.
I'm new to the panel. I'm a member of Parliament representing Parliament. You say you've appeared before the JSC on 4 occasions.
For this matter, in fact 5 matters. The first time I was successful, then I was appointed to the High Court.
I admire your tenacity,
Thank you.
and I want to just ask of you whether you've done some introspection about unsuccessful interview processes previously, and what have you done to address what might have been, or what might have militated against you being successful in the past, unsuccessful in the past.
You have High Court judges, all very experienced, very capable judgments. You're not at loss for choice. In fact, you're spoiled for choice. And the fact that you choose one candidate means at the day that candidate has what you were looking for. It is no reflection on the other candidates.
Thank you.
Is that all from you, Commissioner Trollip?
Thank you.
Oh, okay. You may switch off your mic. Thanks. Commissioner Marumahai, do you have any questions for this candidate?
No, I have none, CJ.
Thank you. Oh, may I just find out from you how many judgments you've written in your 15 years on the bench? Just an estimate.
That's many. I mean,
100,
come very
200?
close to
You did
100.
not answer. So I need to get back to the interview. What I wanted to do was to just check whether you have not printed this yet, because I'm going to send you something that you should print.
Can't
right.
hear you, Commissioner. Just repeat that. Oh my goodness. Commissioner, on the virtual platform, we just overheard your private conversation. Carry on, Judge Baartman. You said close to 100.
That should be close to 100, yeah.
Reported ones? Just a rough estimate.
Reported ones are 3.
Okay. All right. Commissioner Nongonyan.
Thank you, CJ. Good afternoon, Judge Baartman. Thank you very
Good
much
afternoon, Commissioner.
for your presentation and for availing yourself. I'm just curious to know, in your illustrious career, whether you have had an opportunity to deal with issues. Thank you. Whether in your illustrious career you have been able to deal with issues pertaining to Khoisan and traditional leadership matters, community matters, or not leadership.
One of the judgments that I've listed involves the Khoisan and the community, yes.
Was that it? All right.
That's all, Judge.
Commissioner Matolo Tlepu.
Thank you, Judge Baartman. What I wanted to find out, the Deputy President of the Supreme Court actually indicated what that court needs. It was about tax, it was about intellectual property, and I don't remember the one, but I just heard you saying that you have done tax, but I think how much did you do? I think that will satisfy me. How much did you do of what that court needs?
Of tax matters, I've done a lot of tax matters.
And intellectual property, that's what I heard.
Intellectual property matters I have done. I've actually written judgments on it, yes. You must understand that I'm in the Western Cape. We deal with these type matters really routinely. Even in our motion courts, you will have a matter that you must, on an urgent basis, deal with. I must certainly have dealt with them, yes.
And I imagine that that list would include shipping law matters.
Yes, it
coming
does.
from Cape Town.
Yeah.
Okay. It does not appear that there are any more questions for you, Judge Baartman. Let me just join Commissioner Trolip in commending you for your tenacity and thank you for coming back time and time again to present yourself to this body. And I just want to assure you, I happen to have sat with you in a number of matters at the SA, so I know what you're capable of. I don't want you to take your previous failures before this body as an indication that you are not a good judge. So unless there's anything you want to ask us, you are excused.
Okay. Can I thank you, Chief Justice? I just want to bring something to the Commissioner's attention. The South African chapter of the International Association of Women Judges wrote a recommendation for me. It's dated the 2nd of September. When I received it, I saw that in paragraph 1, they referred to me having received a BA instead of a BURIS. And in paragraph 2, actually the sentences 2 and 3 should be deleted. That's not reference to me. I contacted them and we resolved that I would ask the commissioners on paragraph 2 to delete the 2nd and 3rd sentence, and on paragraph 1, it's B juris instead of BA. I think it's fair that you have just not leave it like that. It is wrong. Thank you. Chief Justice, that is all. Thank you very much.
Thank you very much, Judge Baartman. You're excused.
May I be excused. Thank you, Commissioner.